Hey guys, this is John Watts. Thanks for watching this video. I wanted to do a follow-up to the video that we released yesterday, which was about the stimulus checks and can a debt collector get those checks? And I'm not going to repeat that, but what I want to focus on in this video is let's assume that a debt collector has illegally threatened to take your stimulus check. How do you sue them? What do you sue them for? And I thought rather than just telling you about, well, you can use this section of the FDCPA, the Fair Debt Collection Practices Act, or this section, I thought, well, I'll just show you. And this is one of the best places. It's law.cornell.edu. And so this is the FDCPA, and this is section 1692D, which is harassment or abuse. And there's really about three sections we'll look at. We'll look at this one, then we'll look at section E, which is for deception or misrepresentation, and then F is unfair conduct. And this isn't going to be a long video, but I just want to kind of walk you through some of the language or the sections of the statute here. And so you can see if we were suing a debt collector for maybe telling you that they can garnish your check when they really can't, or saying that you have to pay them money, or these bad things will happen, and let's assume those are untrue. What do we do in response to that? So let's look at 1692D, harassment or abuse. And this says, debt collector may not engage in any conduct, the natural consequence of which is to harass, oppress, or abuse. And that's going to give us some examples. So threatening violence, criminal means, obscene, profane language, a list. This would be like, if you're old enough to remember, some restaurants would have a list of people like, don't take checks from these people, or a grocery store might. Advertisement for sale of any debt to coerce payment of the debt, causing a phone to ring. So we're mainly looking at this just general section. When they do something that the natural consequence, okay, just what you would expect and what they would expect would be to harass, oppress, or abuse you, then you can bring that claim. So if they say, hey, we're entitled to intercept your check. Well, that's a lie, and we'll look at that in the next section. But is that harassing? Is that oppressive? Is that abusive? If they start yelling at you saying, you know, you don't deserve this money, and we deserve this money, and we're going to take your money. Well, again, if they have a judgment, that's what we talked about yesterday, then they can do that, assuming your state allows it. But if they don't have a judgment against you, to be making these types of threats and claims and abusive language, I think violates section 1692D. So let's go to the next section. 1692E. This is basically lying, being deceptive. So let's look at the general rule, and then we'll look at some of these subsections, which the subsections are merely examples, okay? So a debt collector may not use any false or deceptive or misleading representation or means in connection with collection of a debt. So if they're lying to you, they're tricking you, they're hiding part of the truth from you, then normally that will violate section 1692E. So if they say they're affiliated with the U.S., like if they say, hey, you know, on behalf of the Treasury Department, we're entitled to, well, they better be with the Treasury Department, okay? False representation. This is a pretty common one. The character, amount, or legal status of any debt. They may say, hey, this type of debt, this old credit card debt or this medical bill, this has been elevated to where we can reach into your bank account and grab your check, your stimulus money. Well, if that's true, then it's not a lie. But 99% of the time, that's going to be a lie, okay? They're lying about the character, the status of that debt. Number 3, if they're not an attorney and they say they're with an attorney or they are an attorney, that would be. This number 4, the representation that non-payment of debt will result in arrest or imprisonment. Well, that's usually just the total scam, people. But how about this? Or the seizure, garnishment, attachment, or sale of property or wages unless such action is lawful and they intend to take it. So if they say, we can go get your stimulus money, and they really can't, then they lied. Okay, they violated this. Number 5, very similar, the threat to take any action that cannot legally be taken or that is not intended to be taken. Okay, Number 8 has to do with credit reporting. Number 10 is a more general one. Use of any false representation or deceptive means to collect or attempt to collect a debt. So there's a few other things, but that gives you kind of a sense of what we're looking at here. So remember, Section D is when it's harassing, oppressive, abusive. Section E, 1692E, is when they're lying to you. They're being deceptive. Now, F is for unfair practices. So again, you'll notice a pattern. We have sort of a general thing, then some examples. Debt collector may not use unfair or unconscionable. It just means really, really unfair, just unjust. So unfair, unconscionable means a collector attempt to collect a debt. So if they say, hey, we're going to show up at your house and bang on your door till you give us the money. Well, that would be unfair. Also a lie unless they intend to do it. If they say, we can just reach into your bank account and grab this. We don't need a judgment. We don't need a garnishment order. We just have the ability to do that because you owe Midland or portfolio or this medical bill. Well, that would be harassing, Section D. It would be a lie under Section E. And I think it'd also be unfair to tell that to you because that's not what the contract provides. And so look at this number 1. Collection of any amount unless such amount is expressly authorized by the agreement. In other words, trying to collect more than the contract allows. Well, I would argue collecting in a way that the contract does not allow would be a problem here also. Number 6, taking or threatening to take any non-judicial action. In other words, that means without a judge to gain possession of property. Normally, we're talking about a repossession or a non-judicial foreclosure. It's what we have in Alabama. In Florida, it would be a judicial foreclosure. They file a lawsuit. But they say, hey, we are going to just write to your bank and take your money. And so they either do that, that's the taking, or the threatening to take. Well, that would be an unfair action. So that would violate Section 1692 F and then 6. Okay, and the rest of this doesn't particularly matter to us. So again, I just wanted you to see kind of big picture, but then also look at these 3 sections. It's not all the FDCPA, but Section D is harassing or abusive or oppressive. Section E is lying to you. Section F is being unfair or unconscionable. So if you're dealing with a debt collector that is telling you they're going to take your stimulus check, you say, well, what legal right do you have to do that? Okay. Or if they are cussing at you, or they are saying, you're a terrible person, you're getting this money and you won't pay this debt. And, I've had them before say, is that the way your mom raised you, to be a terrible human being? Well, that's abusive language. If they use racial slurs, if they talk about your immigration status, if they say, hey, you're some dumb inbred redneck. Well, that's abusive, okay? If they say, we're going to deport you back to where you came from just because you maybe have a Hispanic name, for example, that would be abusive. That would be oppressive, okay? So when they do something to you that they have no legal right to do, and it just kind of strikes you in your gut as like, man, that does not seem right. Well, then, not always, but probably that violates the FDCPA. Now, if you have a question about what they've done and you want to reach out to me, you can always contact us through our website, alabamaconsumer.com, and that's going to be the best way rather than calling, just because we get so many people reaching out to us. It's just easier for me to see what you're going through and then be able to reach back out to you by either phone or email or video and say, hey, here's some questions, or here's what I think we could do to help you, or here's a lawyer, if you're not in Alabama, that might be somebody that you can talk to that can help you. So just be careful out there. This is obviously needed by a whole bunch of people, and the debt collectors know that, and they're kind of sitting there saying, hey, we want to get our money. And if they follow the rules, that's one thing. But when they break the rules, then they ought to be sued. And that'll finally get it through their head. It's more expensive to break the law than to just follow the law. So thanks for watching this video, and I'll catch you guys tomorrow. Have a good one. Bye-bye.